which I will talk in another video, in the video about legal liabilities. So you can watch it and learn more if you want. Then the last category are other laws. I've named them, or they are also named in the literature, direct environmental laws. So for instance, the energy conservation law or the clean production promotion law, they are direct environmental laws because the main aim of these laws is environmental protection. But besides that, we have also what is called here indirect environmental laws. So for instance, the city planning law, which also deals with environmental protection, but which also has other aims like planning, for instance. Or the building law, 建筑法. And then, yes, I right now would like to show you a short history, as you requested me last time, about the highest environmental state institution, the NEPA, SEPA, or MEP. It all started with 1982, when environmental protection became a part of the Ministry for Urban Construction and Rural Development. So at that time, environmental protection was not a part of our own ministry. Then, 6 years later, the Environment Bureau, the NEPA, National Environmental Protection Agency, got its own independent status. Then, 10 years later, the NEPA gets a higher rank and was renamed to SEPA, so State Environmental Protection Administration right now. But this year, 1998, we also have to mention that there was a halving of the SEPA staff due to an important structural reform. So this higher rank does not actually mean that it got more power, because at that time it actually lost some power. Then 2005, the SEPA stopped in a big action 30 large-scale projects for a short time. And this was an issue which was very striking, because it was the first time that SEPA acted very actively. In the same year, SEPA Deputy Minister Pan Yue also gave his groundbreaking speaker interview, which you can find for free on the internet in a German and an English version, how you want it. And I personally think that as a consequence of this interview, together with the main pollution incident in the same year, Minister Xie Zhenhua has been fired. So he, by the way, is also right now the main negotiator in the climate change conferences. For instance, last year in 2009 in Copenhagen, and that year he has been fired. So in 2008, then the last important year, SEPA got the rank of a ministry and was renamed to MEP, so Ministry of Environmental Protection. Okay, this slide I just want to show you the articles, because environmental protection is of course also an issue right now in the current constitution, in the constitution of 82, the Canfa. Okay, so right now I would like to talk a little bit about a main problem in Chinese politics in general, so the so-called Jiao Kuai problem, and also about this structure here. So you can see at the top the State Council, so the national government, and directly under the SEPA, so the ministry or MEP, and then the respective bureaus, environmental protection bureaus. So these bureaus are responsible for the monitoring and the supervision in their respective jurisdiction. So the problem is right now, or yes, some call it a problem, some call it not a problem, is that these bureaus are funded by the respective government of their level. And yes, so this is called the Kuai, as you see here. Kuai Guanxia. So the horizontal linkage, the horizontal level, and then we have this what is called Tiao Tiao Guanxia, so the vertical linkage. the problem about what I talked right now, what I named right now, is that there is sometimes, or quite often actually, a conflict of interest between what a certain bureau, between a bureau and a government on the level under it. So for instance, just to give you an example, I want to show you that. So for instance, if the Provincial Environment Protection Bureau here gives an order to the District Environmental Protection Bureau, and the order conflicts with what the district government wants, this unit here has a problem maybe. And then, as you can imagine, this District Environmental Protection Bureau in this case will of course act how the unit that funds him will want him to act. So this is a problem in Chinese politics, not only with respect to environmental politics, but also with respect to the courts, for instance, because the courts are also financed by the government of the respective era. And this is a general problem. Okay, so right now I would like to talk about the current state of affairs. I have 3 points. So first, the legal density, Gesetzesdichte, Volume. So the question of how many laws actually exist, and the second question of the legal quality. So how good are that laws that exist, 法律素质, and third, some other factors. So first, the legal density. I would like to quote Dirk Bethke. He is a sino-environmental scholar here in Germany. He's worked for the GTZ, and he says, for instance, citation, that China has a similar comprehensive environmental legal equipment like environmental pioneer states. So I could quote other scholars like Richard Ferris, but generally they all say that the legal density is actually quite high. So many environmental laws exist. If not on the national level, they exist on a local, on a subnational level. And this has to do with the principle that Heuser calls the principle of provincial law preceding national law. So this is something like we know from legal theory, the lex specialis derogat legi generali principle, so the principle that says that special laws are more important and are more valid than general laws. Because subnational state entities are allowed, first, to fill legal gaps in national laws, second, to specify national laws, and to enact more stringent norms than the central state. And these 3 points are under the prerequisite that these laws don't run against national laws with respect to the content. So here we can sum up that the legal density is a success. Then with respect to the legal quality, we can also say that it is quite good, but nevertheless some deficiencies exist. So for instance, Stephanie Bayer says that the legal language is often very general and vague, and this produces what is called Rechtsunsicherheit, so legal uncertainty. The people don't know what the terms in a law mean. And statutory duties, Rechtspflichten, EU, are often stipulated only as should, but not as must, so it's not so strong actually. Then another issue is that there exists often an exhortational language style. This has to do with the Confucian legacy of China.